Just a couple of days into 2026, and Donald Trump decided to bomb Caracas to be able to take Nicolás Maduro and his wife back to the United States to face a federal indictment out of the Southern District of New York. There are so many questions swirling about the legalities under domestic and international law as to what just happened over the weekend. What's going to happen moving forward with that federal indictment against Maduro and his wife? And does this have any kind of collateral and consequential, kind of impacts or effects on things like the Alien Enemies Act? To answer all of my questions, I called on my good friend and colleague, Georgetown law professor Steve Vladeck, to be able to explain it all. So here it goes. And when I need things explained to me in ways that I will understand, so that I am empowered, because as I like to say, knowledge is power here at the Katie Phang News Channel, I call on my good friend and brilliant Georgetown law professor, although that sounds like I'm also a Georgetown law professor, which I am not, because I'm not as great as Steve.
I would welcome that. How can we make that happen?
I don't know. They might freak out a little bit with my unorthodox ways. But Steve, man, listen, and Steve Vladeck, folks, if you do not follow and subscribe to One First, his newsletter that also tackles critical Supreme Court issues, then you are missing out. But Steve, man, look, let's just start straight out of the gate with, did what we just witnessed in Venezuela, is that legal domestically or internationally?
No. Good to see you, okay. Katie. Talk to you next week.
It was good to see you, man. Peace out. Thanks for coming to our Tech Talk, people. It was good to see you. Okay, so let's start with you just go.
Yeah.
You know what? Just go. Just explain what the hell is going on.
So it might be helpful to break apart the domestic and international law questions.
Please.
So the international law question is actually, in some respect, the easier one, because there's just no there. So Article 2 of the UN Charter, which is not just some, fancy-pantsy international treaty. It is a treaty that the United States has ratified. It is therefore the law of the United States. Has a rather categorical ban on one nation violating the sovereignty of another, with maybe, Katie, a small exception in Article 51 for self-defense, but there's no self-defense argument here.
Exactly.
And so the only real argument that could possibly be advanced as a matter of international law for why this was legal is if the duly elected leaders of Venezuela asked us to do this, right? If the legitimate government of Venezuela requested our help. But
take a pause. But who gets to define? And by the way, let's just get this out of the way, because I'm a little annoyed that I'm hearing the criticism of this. I am not a fan of Nicolás Maduro, nor are you, Steve Vladeck. We are not proponents of Nicolás Maduro.
I have not had to put away my, Nicolás Maduro, fan poster.
Okay, no. That shit, that's not the case. So I want to know who gets to be the person or the arbiter then in the international law space, Steve, of who's the, quote, democratically or recognized leader of Venezuela.
The recognition question is messy 6 ways from Sunday. And it's messy because you have both the question of sort of the international level, and you have different countries which might have different answers to whether they recognize a particular person as head of state. Let's start at the bottom. There was a period of time from 2013 to 2019 when Maduro was recognized by the United States, by both the Obama administration and the Trump administration, as the legitimate, duly elected, lawful head of state in Venezuela. It was only after the 2018 elections, about which there were serious legitimacy and integrity questions, that the United States and a series of other countries stopped recognizing Maduro. So right off the bat, we have someone who, at least for a time, was unquestionably recognized as the legitimate head of state of Venezuela. It would get messier, Katie, if there was someone standing up and saying, actually, I'm the duly elected head of state and I consent to this. Then it would get messier, right? Then there'd at least be the patina of argument that what the United States has done Friday night was consistent with international law. No one is saying that, right? And so what would be, Katie, perhaps the best possible defense as a matter of international law, just, we don't even have to get to the question of who counts, because no one in a position to make that claim has made that claim.
And especially then this is the perfect segue to the domestic analysis, right? Because what we've heard so far, and of course, this is, take it with the huge, not even a grain of salt, with like a dump truck of salt.
Yes.
We were told by the Trump administration And let's move back for just a hot second, too. The Trump administration, via Secretary of State Marco Rubio, made affirmative representations to members of Congress who have not declared, we're not at war with Venezuela. I just want to make sure this is clear. There's no congressional authorization of war with Venezuela. But Marco Rubio affirmatively stated to members of Congress that this is not a regime change. We are not seeking a regime change in Venezuela. We are not seeking to replace Maduro as head of state or unrecognized head of state with someone else. In fact, the only excuse we were given, although Trump did spend a shitload of time on Saturday doing that presser talking about oil, we were told that the United States law enforcement facilitated the involuntary extradition of Nicolás Maduro to the United States to face an indictment out of the Southern District of New York. Right?
If we want to be really technical, I think the correct legal term is rendition.
Oh, yeah. Touche. Yeah. So rendition occurred on Friday.
Yes.
Rendition definitely being an involuntary act of Nicolás Maduro to the United States to face a multi-count federal indictment out of the Southern District of New York. So this is a law enforcement function, correct?
And so far, right, let's back up. You said something that I don't want to gloss over, which is there has been no consistent explanation for any of this from the Trump administration. There was the president's bumbling press conference on Saturday. There are things that Marco Rubio says he's told people. There are things that, like, Mike Lee has said Marco Rubio told him. But Katie, the best we can piece together is that what you said is right. We still think Delcy Rodriguez, who was Maduro's vice president, is actually the current, at least de facto, head of state in Venezuela. And the real argument appears to be sort of a classic tail wagging the dog, where it wasn't a military operation. It was an arrest operation, and the military was just there to protect those poor FBI guys who we sent into Venezuela in a naked violation of Venezuelan sovereignty from the possibility that Venezuela might shoot at them.
So how do we send American FBI agents onto foreign soil, surrounded and protected by United States American military?
So what the Trump administration appears to be doing, and I want to stress appears because we haven't seen any formal legal rationale, is mushing together two different lines of argument that have been made by the Justice Department in the past, Katie, but never embraced by courts. So the first line is the FBI line. And there's this, as you know, deeply controversial OLC memorandum.
Office of Legal Counsel.
Yep. That was written by then OLC Assistant Attorney General Bill Barr. Yes, the same Bill Barr in 1989. That concludes that the president has inherent constitutional power under Article 2 to send FBI agents onto foreign soil to effectuate arrests for violating the U.S. criminal statutes. So, Katie, you know this from your time as a prosecutor. There are a whole bunch of federal statutes that do have extraterritorial application, meaning that you can violate the law even if you're outside the U.S. So here's Barr saying, and beyond the normal extradition process, the FBI even could go into a country without their permission to arrest someone if there's a valid indictment in a U.S. civilian federal court. And even more crazy, Barr says, the president has inherent constitutional authority, not just statutory authority, to send FBI agents to do that. So that's the first piece. The second piece is the notion that, in general, the president has Article 2 power to protect federal personnel from violent attack. And so, you can put troops in front of a federal courthouse, Katie.
I was going to say, isn't this kind of what we were seeing with the federalization of the National Guard in these cities under this quote unquote theory or premise
of protective power?
Yeah, protective powers.
Right.
Yeah.
And so basically the protective power and the Barr memo had a baby. And the Barr memo is the putative justification for sending the FBI into Venezuela without Venezuela's consent. And then the protective powers, our poor FBI guys might get shot at if we send them into Venezuela. We better send troops to protect them. And if that's not bootstrapping and the tail wagging the dog to a degree that just you've never seen before, I'm not sure what is. But that appears to be, Katie, how we got there.
Steve, I want to just take a slight tiny little footnote detour right now about OLC, because OLC memos keep on getting invoked over time, but they're not law. OLC memos are not federal statutes. They're not law. They are, by definition, a memorandum. Listen, at strongest, a legal analysis suggesting a course of conduct. So the fact that you've said that these theories have yet to be tested, or strike that, have yet to be court approved, does it mean they haven't been tested yet in courts at the same time, or what?
Yes, I mean, so as you might imagine, we haven't done a lot of these kinds of militarized extraterritorial arrest operations in our history.
Understandably so.
And I know we'll talk about Panama and we'll talk about Noriega, but the sort of the short version of all of this is that I think even though those two threads both come from OLC, one is a lot more controversial. Like, there is at least some acceptance, Katie, not just in the Justice Department, but out in the world of law professors and experts, that the protected power makes at least some sense, right? That FDR did not need an act of Congress to shoot down Japanese planes over Pearl Harbor on the morning of December 7th, 1941, right? Like, that seems not insane. The Barr memo is what's insane. And the Barr memo is not just insane, Katie, it has been soundly debunked by, everybody over the 37 years that it's been on the books. Barr never even considers the fact that the UN Charter is actually ratified by the Senate and is therefore U.S. law, right? He never considers the sort of the war powers problem that the memo is basically saying the president can send troops into a foreign country without Congress saying anything, right? I mean, so OLC memos, we did this whole song and dance during the George W. Bush administration with the torture memos, right? Like, these memos are very important from the perspective of providing internal legal rationalizations for what the executive branch is doing. They don't in any way establish legality, right? Like, writing something saying this is legal 10 times does not make it so. And so I guess, part of the problem here is that we have a framework that is based on a highly controversial memorandum that has been, soundly discredited for 37 years, only to have the Trump administration dust it off because no one else is going to hold it to account.
And you mentioned, you said something a couple of minutes ago, Steve, that we are going to assume what's happening here because we have yet to actually read or hear formal legal rationale set forth by the Trump administration. I would say reasonably we can anticipate that in a legal filing, correct? Like, let's just say there's a motion to dismiss, and I'm getting a little bit ahead of ourselves a little bit, but say there's a motion to dismiss filed by Maduro and his wife to get rid of that indictment, and then the government has to respond as to how it was legal that they were able to obtain him. And we'll get into Care Frisbee in a second. But let's talk about Panama, and let's talk about Manuel Noriega, because that one, ironically, it was the anniversary of that too, right? Like over the weekend, which was crazy. But that keeps on kind of getting interjected, and I say it's like the resurrection, the ghost of Manuel Noriega coming back.
I think it's a good episode title, The Ghost of Manuel Noriega.
I think it's fantastic. So talk about why Panama and Manuel Noriega, why Trump can't rely on that as being on all fours as with what just happened this weekend with Maduro in Venezuela.
Sure. So the first thing to say is, there was never any kind of conclusive legal analysis that upheld what President George H.W. Bush did in Panama. So, right, it's at most, it is a historical precedent, not a legal precedent. There's also, Katie, one critical difference. So let's back up for a second. So in 1989, late 1989, President George H.W. Bush sends, I think it's 25,000 troops into Panama, part of what was called Operation Just Cause, with the goal of deposing and then ultimately arresting General Manuel Noriega, who had been the de facto but not de jure ruler of Panama since 1983.
And when you say de facto, not de jure, what do you mean?
So Nicolás Maduro, whatever you think of the elections in 2018 and 2024, he was the elected president of Venezuela. So as a matter of Venezuelan law, he was the de jure head of state, much like President Trump is our de jure head of state. Manuel Noriega was never elected, right? There had been a military coup. And he was I think the second person to come to power after the coup, right, in 1983. And so he never had any claim to legitimate election to legitimate selection under Panamanian law, he was ruling by force, not by right.
Okay.
That's going to come back to matter when we get to recognition. But before we even get there, so President George H.W. Bush sends in 25,000 troops. Katie, two critical factual differences between what happened in Panama and what happened in Venezuela. In Panama, before President Bush ever sent troops into Panama, the Panamanian General Assembly had declared war against the United States. There was a war, at least from the perspective of the Panamanian government. And then second, not only was there a war on paper, but there had been attacks against U.S. personnel who were already stationed in Panama, including the murder of one Marine. So, I don't know that I'm sort of comfortable saying that therefore President George W. Bush was totally legally justified in what he did. But at the very least, there was a provocation. There was a declaration of war by the foreign nation before we ever did anything.
Did the United States declare war by Congress?
So no, we didn't, which is part of the problem. And so I think you could still make a pretty good argument that as a matter of domestic law, actually what we did in Panama was unlawful. But the international law question is much harder for those reasons, right? Because the Panamanian legislature had declared war, because there had already been an act of armed aggression against U.S. personnel. Now you have more of a self-defense argument under the UN Charter. So that's, the Panama scenario, I think both is not a legal precedent and also I think can be distinguished. The other piece of this also is that, again, unlike in Panama, here, we may think that the 2018 and 2024 Venezuelan elections were illegitimate. Maduro was still, at least nominally elected by the people of Venezuela in a way that Noriega never was. And I think that's relevant politically, and I think it's also going to be relevant as we turn toward what happens to Maduro himself in this criminal prosecution.
So I know that Manuel Noriega raised several defenses, even though he, quote, surrendered to U.S. forces, and then he was brought back to the United States, specifically to Miami, by the way, right here in the Southern District of Florida, to face his indictment, which also hauntingly mirrors a lot of the allegations against Nicolás Maduro when it comes to narco trafficking, weapons offenses, etc. But Noriega raised several legal defenses about the way within which he was deposed and brought to the United States to face these charges. Can Maduro raise these same defenses? And if they are they dead on arrival?
So I think there are two buckets here. And I think one of them has no chance. And one of them I think is actually going to be where much of the action is. So the first bucket is, can Maduro challenge his prosecution based on the means by which his presence in the United States was secured, right? Based upon the rendition.
AKA, we call this in the law personal jurisdiction.
Correct.
How does a court in the United States get jurisdiction over the person of that party, the defendant, et cetera?
Okay. Right. And so normally in normal personal jurisdiction land, you cannot forcibly compel a defendant you cannot kidnap someone and bring them into the court and therefore establish personal jurisdiction over them.
Yeah.
Well, the U.S. Supreme Court has a different view about this in criminal cases. And so that you already mentioned the Kerr-Frisbee doctrine, named after cases shockingly known as Kerr and Frisbee, which stands for the proposition that a federal criminal court in the United States is not divested of personal jurisdiction over a defendant, no matter how the defendant's presence was secured. Even, Katie, in cases in which the U.S. government forcibly abducted the defendant from foreign soil, which was the facts of a 1992 case called the United States versus Alvarez-Machain. So that's not going to be a great line of argument for Maduro, even though maybe it should be.
Well, so what could see some action then, you said?
So the real question, I think, is going to circle a lot around what's known colloquially as head of state immunity. So, right, this is where things get really fun and crazy. There's something that's called foreign sovereign immunity, which is recognized by statute. We have a whole statute called the Foreign Sovereign Immunities Act. Head of state immunity is different. Head of state immunity is a common law immunity that the United States has recognized all the way back to a John Marshall opinion from 1812. And it stands for the proposition that the United States cannot prosecute, cannot even civilly try, right, official acts of a foreign head of state who has been recognized as such by the United States. And that's the sticky wicket, right? The recognition piece is where this gets very messy. So,
and does that turn heavily on the facts of the recognition?
yes.
Meaning, how has the United States interacted with Maduro to date? Have they chosen his vice president, for example, to negotiate with versus Maduro directly? So it becomes a very fact-intensive analysis.
With historically, Katie, at least a lot of deference to the executive branch, right? Which, yay. In Noriega's case, that made the issue fairly open and shut for the 11th Circuit, for the federal appeals court that has jurisdiction over Miami. The 11th Circuit said, even if we weren't going to defer to the Bush administration's claim that they don't recognize Noriega, the reality is he was never the de jure head of state. And so he's not entitled to head of state immunity at the very least because he was never really the head of state. That's not true in Maduro's case. I mean, again, this goes back to something we talked about a few minutes ago. From at least 2013 to 2019, the United States did recognize Maduro as the legitimate, duly elected head of state of Venezuela. If you look at the indictment, some of the offenses charged in the indictment overlap with the time period during which we recognized him as the head of state of Venezuela. And
we got to remind people, though, Steve, that indictment that was just unsealed over the weekend and kind of touted around like some, prize calf by Pamela Joe at the DOJ, that's a superseding indictment. So there was an original indictment actually against Maduro. And again, Maduro, we are not supporting him. We're not fans. He's no angel. But I'm just saying there was an original indictment that he was facing years ago. And this indictment supersedes, meaning it replaces that older indictment.
And I think we don't know the dates of either indictment. What seems to be different about this second indictment, among other things, is that it adds Maduro's wife, Celia.
That's right.
Right, who was not a party to the earlier indictment. And so when Pam Bondi says, these guys have been fugitives from the law, not sure how you can be a fugitive from an indictment you didn't know about, but that's, why should logic stop us?
But there's a thread to pull from there, though. Which is why, and Margaret Brennan actually asked this question of Marco Rubio yesterday on the Sunday shows. If you have warrants for the other people that are in the Maduro administration, and I guess maybe this is their plausible excuse if you're Trump, right? I wasn't doing regime change. That's why I didn't depose all of the members of the Maduro administration.
I think that has to be the argument, right?
Right? So I didn't touch them. I only touched Maduro and his wife. But if you have arrest warrants, bounties on the heads of several of these kind of top members of the administration, and by the way, the VP in Venezuela, it's not like anybody's made allegations that her hands are clean either. Let's be very clear. Like, why would you not also facilitate the arrest of those people? Is it because they weren't facing an indictment in the U.S.?
So we're back to the problem of the sort of complete lack of coherence coming out of the Trump administration about what this is about.
Because
right?
It's a day ending and why.
Some days it's about in 1 hour it's about arresting Maduro. The next hour, it's about regime change. The next hour, it's about oil, right? And these are very, very different arguments that would have very different consequences. I will say, that we didn't arrest other people is probably a political obstacle more than a legal one, right? The real question that's going to come up in the Maduro prosecution is how can we prosecute someone who, for at least much of the indictment period, we viewed as the legitimate head of state of a foreign sovereign. And
even if they're committing criminal activity.
So historical, that doesn't matter. I mean, Katie, part of why there was a movement after World War II to create meaningful international criminal responsibility, even for heads of state, is because it was understood that domestic legal systems usually lacked the capacity to hold foreign heads of state criminally liable. Right? That this is why you needed the Nuremberg War Crimes Tribunal, the Tokyo War Crimes Tribunal, the International Criminal Court. So, unless we're going to sort of turn tails on this entire doctrine, a lot of the Maduro case is going to turn on which acts he's being prosecuted for that post-date his de-recognition and whether de-recognition even matters. I mean, there hasn't been a case like this where you had someone who was for period number one, a recognized head of state, and then for period number two, a non-recognized head of state. That's a novelty that's going to cause a lot of, I think, uncertainty and mischief in the pretrial proceedings in this case.
Okay, I mean, I don't want to be totally weird about this, but it also kind of reminds me, it smacks a little bit about the presidential immunity analysis too, right? Does it fall within the perimeter of the conduct that you're doing as president? Does it not? I mean, part of that was just, are you president? Are you not? But okay, so let's take a little bit. Let's pull on another thread.
Can I just say one thing about that, Katie? I mean, I think
Yeah. Is that weird that I brought that up?
It is worth not sleeping on the possibility that now a defendant like Maduro can point to John Roberts' majority opinion in the Trump case
and say you get immunity as president, right?
And for even more immunity than we had recognized before last, or July of 2024.
Can you imagine? I mean, yes. I mean, I guess I could imagine. Quickly,
can you imagine as a question has become much more loaded in the last 11 months?
Just 4 days or 5 days into 2026. Let's talk about the Alien Enemies Act, shall we, for just a little bit, because I want to kind of push this along. For many months, I was saying that the provocation and the hostilities with Venezuela was a way for the Trump administration to bootstrap the executive order that was done and the declaration and the invocation of the Alien Enemies Act to justify a lot of the horrific conduct we've seen from the Trump administration when it comes to immigration enforcement, when it's come to the illegal and unconstitutional lack of due process removal of people like Kilmar Abrego Garcia to CCOT. And now we have still no declaration of war. We still have yet to see evidence of Tren de Aragua with these people that have been deported illegally. But we now have a deposed, I'll use that adjective, deposed leader of Venezuela, now in custody in the United States for his role as a, quote, alleged narco trafficker. Does this all kind of feed kind of into the DOJ machine of bolstering the argument that it is okay then to do this shit under the auspices of the AEA?
So, a couple of folks have raised this concern publicly, and I get where it's coming from. Let me say, I think there are two reasons why I'm not too worried about that. So reason number one, the Alien Enemies Act question, whether the president can lawfully invoke the statute in the first place, turns on whether we have a declared war. We don't.
Which we don't.
An invasion. We don't.
Which we don't.
Right? Or a predatory incursion by a foreign government into the United States. And so going over there and bombing Caracas, I think doesn't get you there if we weren't there already. So I don't know that really changes that analysis meaningfully. But in any event, I mean, Katie, most of the litigation to date about President Trump's March 15, 2025 proclamation has not been about its underlying validity, but about the process that individual detainees are due before they can be removed from the country.
Yeah, notice and the opportunity to be heard. Yes.
Right. And so the Supreme Court back in April of last year, even though they said you've got to bring these cases as habeas petitions, it also said unanimously all of these detainees are entitled to notice and an opportunity to challenge their basis for removal before they can be removed. That was really, I mean, more than anything else, Katie, that was the move that put the kibosh on the Alien Enemies Act, because the whole reason why the Trump administration wanted to use it was because it thought that it could use this statute for mass summary removals. And even if the courts do ultimately say, oh, well, that's close enough with Venezuela, you still have this requirement of individualized process, which is going to defeat and thwart, the utility of this statute as a mass summary removal device. That's why I think this doesn't move the needle that much. That said, the Fifth Circuit, the en banc Fifth Circuit, is set to hear oral arguments on all of this mishigas on January 22nd. So 2 weeks from, I guess, this Thursday. And so, we'll see. But I think that there's lots of other bigger stuff that is problematic about what happened Friday before we get to its implications on litigation, where I really do think the big move has already happened.
Well, as always, thank you seems to be insufficient for you and your time, your scholarly, insight, and just frankly, just the way you're able to explain things in a way that I can understand. And I know everybody who's tuning in can understand. Thank you, Steve Vladeck. Again, if you're not following and subscribing, his newsletter is called One First. And make sure you're following him, not only at Substack, but also on social media. He's definitely, and TikTok, by the way. He has ventured into the land of TikTok.
It's all Karen's fault. Okay,
you got to bring it to the masses. You got to bring it to the masses.
It is entirely Karen's fault. I just want to say that.
Karen is the brains in this operation. I will tell you that. Professor Steve Vladeck, thank you for your time. As always, I appreciate you.
Thanks, Katie. Great to see you.
Good to see you. Katie Phang here. We launched the Katie Phang News Channel in partnership with the Midas Touch Network so we could bring you the latest in legal and political news. Straight, no chaser. So if you're a fellow truth teller, hit that subscribe button and share the word about this channel so we can build a high information America together.